Hi there, it's me, Tracy B, and you're listening to another episode of Self-Represented in Family Court. Today, I wanted to talk to you about something that I talk about frequently when I'm talking about representing yourself or handling your own divorce or custody case. And that is actually who you are as a pro se litigant, who you are as far as what you do financially or professionally, or just the role you play in your family dynamics, in your relationship, in your marriage. So I recently did an episode on strategic efforts, strategic moves, strategic things to do as a stay-at-home mom. Today I want to talk to you about being a business owner and being pro se. Let me just back up for a second. In the recent weeks, I've been appearing on podcasts almost incessantly. And I've been doing that as a deliberate intent to spread the message, to spread the word about pro se self-representation being a viable option for family court, family law litigants. Why do I think it's such a viable option? Because being pro se in family court in 2025 is very different than what it was 15, 20 years ago. So much has happened within the last 15 years, actually the last 5 years. The pandemic had really set a wave of different ways of doing things, different theories, different values, different beliefs, different mechanisms, different processes, different methods, different laws, you name it. And because of that, it changed the way we view almost everything in life, actually. But it definitely changed the way we show up in places like family court. Why? Because we've learned so much. We've grown, we've evolved, we've just improved in a lot of ways. And although the pandemic was catastrophic, traumatic for a lot of people, because a lot of people lost loved ones and lost their professions and lost their identities and lost relationships, they lost. But as I am one of those people that I'm always going to find a silver lining in the storm. Storms do end, and a lot of times they are rainbows at the end. And this is no different. And so I think a lot of people, whether they know it or not, whether they acknowledge it or not, have become more resilient, more determined, more aware. A lot of us have grown, including myself. And so, again, family court is no different. There's a lot of things that change in the way people show up to family court, in family court. And so, because of that, being pro se now has a lot of nuances that make it viable, make it doable. And I'm not talking about making it and just winging it. I'm talking about people are coming out on top, still standing. Yes, handling their own case. But what I also understand is that now, because of the pandemic and anything else that has happened in the last 10, 15 years, that there are some people who are just not prepared or not ready or not apt to handle their case. So I wanted to go on and do this public campaign, this mission to spread the word that pro se in 2025 and beyond is definitely a viable option. You can do it successfully and accomplish or achieve your goals. So with that being said, there are some instances where being pro se are not ideal. And I get asked this question often. Who should not self-represent, Tracy? Who do you think, or what issues or circumstances do you think are not appropriate for being pro se or for self-representation? And I must say this. I actually had to do some soul searching myself because I can be an idealist. I can be that altruist that thinks that I can rescue and save everybody. And so last year I had to come to the realization that I can't do that. And I found that it was not only unrealistic, but it was unethical and irresponsible, actually, to just think that anybody can go out there and handle their case and do it successfully. So I actually narrowed down the people that I think, or the issues or circumstances that I think are actually capable of getting through a pro se family court case without sacrificing, without damaging, without committing family law suicide in their case. But with that being said, I also believe that a lot of people that lawyers or other divorce professionals think should absolutely not be handling their own cases, there are some instances where they absolutely can, because of the resources, of the information, of how people have learned, how people have developed, how technology has advanced. There is more circumstances, there are more people that I believe, in my professional opinion, in my honest professional opinion, can actually successfully handle their divorce. Again, there are some instances where parental alienation is an issue. I absolutely don't think you should be pro se if you have parental alienation as an issue in your case, especially when it's mid to high level parental alienation. I really think you not only need a lawyer, you need a team. You need mental health experts, you need co-parenting coaches, you need high conflict coaches, you run the gamut. You need someone who specializes, a team who specializes, or who are quite familiar with parental alienation. So I will say that. But when it comes to individuals in their roles or their titles, I do believe that there are more people who are equipped to handle their divorce or custody, despite the label or the title or the identity or the role they play. So this week, I wanted to focus on the self-employed or the business owners who are actually going through divorce. And that is a sort of nuanced title role, because usually when businesses are involved or self-employment is involved, there are issues with valuation, with assessment, with accurate income and revenue, and classification of separate versus marital property, and all of those things. So it does make things a little challenging, but I do think that it is possible to be self-employed or a business owner and actually handle your case on your own. So that's what I want to talk to you about today. If this is you, sit down and listen. Let me have your attention for the next 25-30 minutes, because that's who I want to talk to. So if you are in a divorce, mid to high conflict divorce, and you happen to be a business owner, you happen to be a self-employed 1099 independent contractor, someone who actually is responsible for filing and paying their own taxes, that's who I'm talking to. If this is you, let me talk to you about some things you really need to understand when you are opting to be pro se. You can be pro se for parts of your case. You could be pro se for the entire length of your case. You could be pro se with some assistance. Either way, the things that you need to be aware of are going to be a little different for you than it would be for someone who is a W-2 employee, right? We're not going to ignore that. And it's going to be a challenge. If you're not organized, if you're not good at research, if you're not good at problem solving, if you're not good at delegating, if you're not good at management, if you're not good at any of those things, you're not going to be good at being pro se. I don't care what you do, but particularly if you are a business owner or a self-employed professional. And my guess is if you were not good at any of those things, you wouldn't be self-employed or a business owner, because it takes a lot of extra effort and work to be successful as a business owner or self-employed or independent contractor or the like. So if you had an attorney and you were any one of those, your attorney would probably do a lot of the organizing, the research, the delegating, the management, and all of that. But since you don't have one, you don't have one that's representing you, you are in a specific class where you need to understand what you can do in lieu of what your attorney would do if you had one. So let's start with actually your mindset. Your mindset is very important. Your mindset, as it is in business, should be the same in family court. You have to have that mindset where almost open-minded, creative, strategic, a critical thinker, researcher. You have to have that. Your mindset has to be, I can do this. And usually when someone is thinking, I can do this, all of those things I just mentioned are actually associated with, they actually fall in line. If you believe you can do this, honestly believe you can do this, not saying you can do this because someone gave you some affirmations and you're just repeating the affirmations. You really believe you can do this because you know your skill level, you know your tolerance, you know your capabilities, your strengths, you know that. If you believe that you can do this and you've done something similar by running a successful business, then you're off to a great start. Your mindset is very important. You have to approach this divorce like it's a business deal. You have to be objective, you have to be analytical, and you have to be focused on outcomes. You have to set goals, and you have to be focused on the outcomes, achieving those goals. That's always a very good starting point, your mindset. Thinking that you can do it, having an open mind that you can do it, and truly believing and behaving as if you know you can do it. The other thing is that you need to be really organized. You need to be really organized and have all your statements, your financial statements, your profit loss statements, your tax records, your bookkeeping, your payroll and personnel, your losses, your debts, your liabilities, even your licensing, your credentials. You need to have those things ready. Your business formation should be intact, all I's and T's, all I's dotted and all T's crossed. Business formation meaning your LLC or corporation, that should be clear, that should be updated, that should be coherent. Your tax records should be up to date. They should be as true, quote unquote, as possible, accurate. You should have a professional actually doing that, not you yourself. You should have someone doing that for you. Your bookkeeping records need to be accurate, need to be complete, need to be on point. You need to have your liabilities, your debts, those statements, they need to be clear, they need to be up to date, and they need to be aligned to what you have in your tax records. So when you're accumulating documents, they should all support each other. They should all back up anything you might have had in another document. So for example, in your tax records and your profit loss statements, they should actually be aligned with your bookkeeping records, with your actually accounts receivables and accounts payables. If you don't know how to do that, if you don't know what to do, you absolutely need to hire somebody. If you're pro se, you need to hire, but you can't take any risks. You can't take any chances by bringing or submitting those documents to the other party and them finding loopholes or finding opportunities to convince the court that you lack credibility because of the omitted or the inconsistent entries that they might find. And if you're pro se up against a skilled opposing counsel, you don't want to give them any more leverage than you absolutely need to. You also need to be very astute all the laws that apply to you. I'm not talking about just family law. I'm talking about you need to know the IRS regulations. You need to know the laws that apply to whatever certification or licensure you have. You need to understand the employment laws if you have employees and personnel. You need to have a good understanding of all the laws, federal, state, and local laws that apply to you. Because in the event that your case goes to trial and you're actually cross-examined on those things, you can be found as lacking credibility. And once you are found to lack credibility in one area, the court can assume or presume that you're lying in other areas. It makes perfect sense to be sure that you're aware of the laws, the regulations, the statutes, federal, state, and local, that applies to you, applies to your business, applies to your employees, and etc. So that's very important, because I know a lot of people are not so savvy. They run their business and that's it. They are not good on the business side. They are not too involved. But that's not an excuse. Unless you have professionals on your payroll or that you're paying that are willing to come into court to testify on your behalf when you don't understand. Because I don't understand everything about business. I still don't. And I've been in business off and on for the last 20 plus years. But there are some things that I just don't understand. And that's okay, because if somebody needs to ask me about something, I think I'm ready to answer those by having somebody else answer them for me, because I'm not trying to be a master at everything. And if that's your case, if that's your situation, that's fine. Just make sure you have somebody ready to come into court to explain some things for you, and that they are credible, that the judge is likely to find them to be credible. Okay? So that's also very important. So you need to have an open mind. You need to be organized. You need to know the law. Presenting your case, though, is where it gets really tricky, because not only are you presenting your case as a litigant, you're presenting your case, the financial or the business side of your case, on your own. Now, when I say on your own, I don't think in most cases you should try to present every aspect of your case, that part of your case rather, without the assistance of a financial expert, a divorce financial expert. There are some people in the divorce industry who actually are equipped, trained, certified to help people like you make sure your case is presented in a way that is cohesive, it's organized, and it's persuasive. I did an episode a few weeks ago about divorce professionals. Maybe you should look for that and listen and come back and resume listening to this one. Because if you need help with putting things together to present a picture to the court that your business is worth X amount of dollars, your business generates another X amount of dollars or Y amount of dollars, your business has the potential to be valued at Z amount of dollars, then you might need somebody to help you position those things in a way where the court actually receives them and again finds them credible. Because it's one thing to organize documents, package them up, and just show them to the judge and to your opposing party or the opposing counsel. But it's another thing to do that and ensure that it's actually believable, that it's actually something that the court finds believable, that even when opposing counsel tries to poke holes or question the legitimacy or the validity or the veracity of them, that the judge is on your side, and just from looking at the way you presented those things, have convinced the court that they are verifiable, they're true, they're accurate, and that therefore you should be found credible. That is where it gets really tricky. That's where actually I come in and help, because I'm not a financial expert. I'm not a financial analyst or a CDFA or forensic accountant or any of those things. But I do know, or a tax accountant or a bookkeeper, I'm none of those things. But I do know how to package things so that the court believes it. And it would help me, if you're not going to get an attorney to help you in that aspect of your case, it would help me if you worked with somebody like that, if that was part of our team that would actually package it all together and I put the final touches on it to make sure it's presented in a way that the judge is going to find it credible. That is a huge part of where a lot of pro se litigants mess up at. Not only do they not organize things appropriately, dotting all the I's and crossing all the T's, but some of them, even when they do that part, when it comes to presenting what they've organized and put together, when they present it to the judge or to the court, it's not done in a fashion that makes the court or encourages the court to find it believable or find it accurate or find it truthful. And so if you're pro se and you insist on doing most or all of your case on your own, then you have to understand that there are some times when you're gonna need somebody to help you do certain aspects of it. Again, I am here for that. I am a strategist. That's exactly what I do. I help people cover those blind spots that they're not aware of. Even if you have an attorney, sometimes working with an attorney, you're still going to have some blind spots. And I can step in and help you cover those blind spots, help you understand exactly what some things mean or what you need to do or how you need to do those things, or help you decide which financial expert you need to get involved in your case as a business owner or a self-employed or 1099 person, professional. So that's very important. When it comes to discovery in a case like yours is probably going to be massive. Massive, yes, because the other side, if they're represented by counsel, if there's questions about value, about income or revenue, about liabilities, the opposing counsel is probably going to want documents, testimony, you name it, to prove or disprove whatever it is you're asserting as far as your business is concerned in your divorce. And so if that's the case, discovery is probably going to be massive. That means they're going to probably use several divorce tools or methods, or all of them, and it could get really costly and really lengthy. So that's another reason, another area, another circumstance which you might want to have someone help you organize things, help you put things together in order, help you prioritize things, help you understand things. And again, I'm here to help you through that. And maybe a CDFA or a forensics accountant or whomever we deem necessary to help. But discovery is probably going to be a huge portion of it. Sometimes depositions. A lot of times there are depositions involved. And as pro se, if you are ordered to do a deposition, you definitely need help preparing for being questioned under oath by opposing counsel. You most definitely need some assistance. You should not be going to a deposition without being prepared for the type of questions they're going to ask, the type of documents you'll need to bring, knowing when to object, understanding the rules, understanding how you can use deposition to your advantage. You should not be doing that on your own. Again, you could do it pro se, but you should have someone to help you through that stage where you are getting some sort of guidance and assistance so that you're not going in there and, again, putting yourself in a position where the court is going to find you that you lack credibility, or that they question the validity or the veracity of whatever it is you're submitting to the court. So that's huge. When you're pro se and you're a business owner, one of the other things you might need to do is get a business valuation, where a professional comes in and values your business. You might say it's worth $250,000, and the other party might dispute that and think that it's worth more because they either worked with you or they've gotten accustomed to a certain lifestyle, knowing that it's way more than what a business worth $250,000 would actually afford you or them. And so if that's the case, then again, you would probably need a forensics evaluator and or a business appraiser, depending on the type of business, depending on the industry, depending on the climate. There's so many different variables, but you should most certainly have someone to help you do that. Again, you're going to need someone to help you maximize working with a forensic accountant or business evaluator, because they can be expensive. And if you're going to use them, if you're going to need one, if the opposing party is going to ask that you have one done, you need to make sure that you maximize their services, that you don't get ripped off by spending a crap load of money unnecessarily. And you're going to make sure that they do evaluation that's very accurate and very close to what you value the business as. So that means providing information, working with them, understanding what they want, what they need, and using that to your advantage, to your benefit. Again, I can help you with that as well. So that is another thing that you have to literally keep your mind open to when it comes to being in the midst of a divorce and being a business owner or 1099 or self-employed. Another thing is, if you're going to go to trial, you need to understand that trial as a business owner, where the value or the assets of the business are in question, your income is in question, those trials usually take very long, and they can be very expensive as well, because a lot of times you'll need to have experts involved. Some of those people that you've worked with along the way are going to need to come in and testify. And usually when they come in and testify, they usually want to be paid up front and they usually require a half day, a full day. Some of them have their own way of charging or billing you for testifying, but it's something that you have to literally factor in to your case from the beginning. Absolutely from the beginning. So that is something to keep your eye open for and to keep your mind set on from the beginning as a perspective down the line. Not to mention that having an expert testify in your case can be way more helpful than submitting reports or just you testifying. They can be really helpful. Another thing is to think about the benefits of spending money on things like an expert or a financial professional or the like. I'm thinking, if you are a business owner and your business has sustained the family for several years and you've managed to do that especially without going under at any point, that you have something worth defending or fighting over, depending on whatever your position is. So when you do a cost-benefit analysis, which is something you absolutely need to do, you should definitely factor in how much is the cost of defending or opposing or pursuing a claim about your business is going to benefit you. How much is the cost of doing that is going to benefit you? Because if your business is just started, even though it's been sustaining you, but it's not even a year old, and you're saying because it's not a year old, it's only valued at $200,000, and the other party thinks it should be valued at $700,000. Do you really want to spend $50,000, $60,000 to prove that the business is really only worth $250,000 when the business is a year old, and doing that might actually cause you to go out of business? Is it something you want to pursue if it's a business that's less than a year old and your marriage is only 3 years old, and the issue with your business is child support and or alimony? Alimony may not be such a big issue because the marriage is so young that don't know if you really want to fight over the value of your business for alimony purposes, because chances are that other party is not going to get much in alimony, if anything, anyway. Or child support is something that you know you're not going to have to pay but so much because the other party happens to be a six-figure earner, and you know the difference to offset with the cost of child support is not going to be that much. So these are things you need to figure out on your own, or again, I'm here to help you. Those are the kind of things, exactly the kind of things I help people work their way through, because there's a lot of legal blind spots, a lot of legal voids, particularly when you are pro se and you're a business owner. And there's a lot of things, a lot of services and issues and claims and defenses and methods that are going to be enmeshed in your case that you may not be aware of. And that doesn't mean you need to run out and retain an attorney to help you get through that. It just means that you need to be aware from the beginning of everything you're about to embark on and prepare accordingly. Either way, if that's something you want to work on with myself, let me know. In your situation, I would suggest working with me on at least 3-month basis so that I can get to understand your business and how it works and how it functions, and get an idea of what the true value is, not from a financial standpoint though, because there's value to businesses that goes beyond money. But I can understand that, and we can work through those cost benefits analysis and everything from there, moving on. So if that sounds like something you think you need, feel free to reach out to me. We could do a 15-minute strategy session to discuss how I could help you, and we could actually start on preparing your case map so that you get a clear idea, a clear roadmap as to how you should move through the divorce as pro se, having to defend or make a claim or take a position as far as being a business owner or self-employed or 1099. That's it. That's all I have for you this week. Thank you so much for tuning in. If you need to reach me, you can always do that by going to my website. There's a page on there where you can fill it out and let them know you want to contact me. I always answer. If you want to set up a call, you can do that there as well. Or you can just email me directly at tracy@thedivorcesolutionist.com. So until next time, thank you. Take care.